but Senator Wiener, proceed with your next bill.
Thank you, Madam Chair. Thank you, colleagues. Next, SB-421, which is a long overdue reform of California's sex offender registry. Colleagues, currently today, California is one of only 4 states that still require lifetime registration for all registrable sex offenses. We treat all offenders the same, regardless of the age of the offense, regardless of the nature of the offense, no matter how minor or how dramatically serious. It's all treated the same. People have to register as sex offenders for the rest of their lives. The only other states that still use this outdated approach are Alabama, South Carolina, and Florida. In fact, federal law requires states to have a tiered approach to sex offender registration, and California continues to flagrantly violate that federal law. California's sex offender registration list currently has more than 100,000 registrants, far more than any other state. The majority of these people are considered low risk to reoffend, and yet they are on the list for the rest of their lives, and law enforcement has to engage in endless effort and paperwork to keep them registered and to monitor them. This large number of people, it forces law enforcement to spend significant resources just processing the annual paperwork to keep the registry up to date, when those resources should be spent monitoring high-risk offenders. Something like 2/3 of law enforcement resources spent relating to sex offender registries are spent doing these administrative tasks rather than actually keeping the community safe. The large number of people on this registry prevents the registry from being an effective tool for public safety. I just want to be clear. The way we've structured this registry with its massive number of people for life, it undermines effective law enforcement, and that is why we have a broad coalition of law enforcement enthusiastically supporting this bill, because they know that a more focused sex offender registry will enhance public safety. I also just want to say, and I mentioned this earlier with respect to another bill, that the way that the sex offender registry is structured right now has a hugely damaging impact on the LGBT community. LGBT people are treated differently than straight people in terms of young people engaging in sexual activity and potentially becoming a registered sex offender. If you are gay and 18 and have sex with someone who is gay and 17, you will become a registered sex offender for the rest of your life. A straight relationship would not result in the sex offender registry. In addition, there are gay men now who might be in their 60s or 70s or 80s who are registered sex offenders because they had sex in a park 40, 50 years ago, and to this day they are still on the registry. This registry has significant negative impacts for LGBT people. This overbroad registration also has significant negative impacts on individuals, on their families, on their communities. People required to register for life face lifetime barriers to stable housing, leading to higher rates of homelessness and barriers to employment and greater poverty. And when people face these challenges around housing and employment, that makes them more likely to reoffend than if they had stability in their lives. Family members, and particularly children, are profoundly impacted as well. By creating a path for people to get off of the registry when they are not a risk to reoffend, SB 421 will make our system fairer and more just. California urgently needs a new registration system that improves public safety by focusing attention and resources on high-risk and violent sex offenders. After decades of research, we now have a much better sense of who is high risk and who isn't. The current registry does not even attempt to account for this distinction. SB-421 was developed by California's Sex Offender Management Board in consultation with law enforcement and reflects the best practices on how to effectively manage sex offenders to protect the public. Every crime that now requires registration will continue to require registration under this bill. The bill places the offenses in 3 specific tiers, either a lifetime registration for the highest risk offenders, a 20-year registration, or a 10-year registration. And at the end of the 20 years or 10 years, you're not automatically off the registry. It just means that you can petition a court to be removed. Individuals determined to be high risk, again, are placed in lifetime registration regardless of the nature of the offense. You'll see that there is a broad coalition of law enforcement supporting this bill. In addition, the California Coalition Against Sexual Assault, CalCASA, the group that advocates for victims of sexual assault, is supporting this bill. Criminal justice reform groups, including the ACLU, are supporting the bill. This is a coalition that we don't see very often. With me today are several witnesses to testify on behalf of the bill. First, Nancy O'Malley, the District Attorney of Alameda County, Brad McCart from the Los Angeles County District Attorney's Office, and Lorena Campos from CalCASA. I know there are several members of the committee who have indicated they're interested in being joint authors. I won't speak for them. They can say it for themselves, but I want to thank you.
All right, let's have the witnesses in support. And apologies that this is a very serious bill and I won't have a proper hearing, but we also have to evacuate the room soon. So if we can be as concise as possible, it'd be very helpful.
Sure. Why don't you...
Good afternoon. I am Nancy O'Malley. I'm the District Attorney of Alameda County. I also chair the California Sex Offender Management Board. And I come to that work having been a rape crisis advocate volunteer when I was in college. And I've spent my professional life combating both sexual assault and finding measures to prevent sexual assault. The KSOM, we call the Sex Offender Management Board, is a statewide multi-agency board of those individuals, all of us working in the field of sexual assault and treatment of sex offenders. This board was created by your legislature back in 2006. And I will tell you that it was shortly after that that we first started to look at the issue of and the complexity of the the registration system as it exists today. Our vision and our mission is to decrease sexual victimization and increase community safety by addressing issues, concerns, and problems related to community management of adult sex offenders. We are also identifying and developing recommendations primarily to your legislature to improve policies and practices. And from day one, our board has been committed to following making evidence-based recommendations and not those that are relying on our emotions. We have also served as technical advisors to your board, to your legislature, and have been involved with significant legislation that we believe have helped to improve public safety and balancing between the rights of sexual assault survivors as well as those individuals who are living in our community who have been convicted of sexual assault crimes. I would like to say that this bill is very important to us. We have been working on it for over 5 years. We started by taking it apart section by section. We evaluated the effectiveness of what the research told us. We then started to recraft the legislation and brought in a lot of partners and consultation, particularly with the Los Angeles District Attorney's Office, so that we could create what we believe is a very substantial, efficient, effective bill that will advance public safety. And we also, every step of the way, we vetted it with many, many groups so that people could understand why this is an important bill and an appropriate bill. I will tell you that we are much more educated now about how we manage sex offenders in our community. As Senator Wiener said, that what we know is that people who are disenfranchised, that creates instability. The issues that they confront psychologically and in other ways don't get addressed. But we have, through the Sex Offender Management Board and your legislature, is that we have created several measures that have educated us and give us great confidence that this is the appropriate bill and system that we should be working under. Specifically, we have created the containment model, and that is a particular therapeutic modality for sex offenders who are back in the community. It is the law now that every person who's convicted of a sex crime that comes out of incarceration must participate in this research-based therapeutic model. And we're seeing the recidivism rates for people who are successfully completing the treatment reduce significantly. We also have, we've also brought into the system a very substantial validated risk assessment tool, the Static 99 now R, and work very closely with the creator of that, based on his research, the creator of that assessment tool. So as Senator Wiener said, we have a better place to evaluate who poses the greatest risk to our community for reoffending. Every person who is convicted of a sexual assault crime now has an evaluation under the Static 99R. And SRATSO, which is the state authorized risk assessment tool, as part of the KSOM, does extensive training with those individuals who are tasked now to administer that tool, and that being probation officers and parole officers or people from CDCR. I will tell you that California, the research from the Department of Justice tells us that we in this state have rated the highest for predictor accuracy in the use of the Static 99R on an international level. So compared against other countries, as well as our own country, California rates the highest in their accuracy for predicting risk and risk of harm. I say all this because I want to provide a platform to why SB-421 is such an important bill for us. As Senator Wiener said, that there are over 104,000 people on the sex offender registry. In my county, we have a task force who monitors sex offenders and ensures that they are registering and they're doing what they're supposed to do. But it's an overwhelming task for law enforcement. And we are treating the person who, I actually received a phone call a couple of years ago from a man who said that he had been convicted of exposing himself when he was 19. He was in Berkeley, and that he was about to turn 80. And could he just not have to register anymore for his 80th birthday? And the fact is, I said yes, but the state said no, because that was the law. So as just can't emphasize enough that we're treating everybody in exactly the same way, and not everybody poses the risk that the most serious offenders do. For that, I urge an aye vote.
Great.
Good morning. My name is Brad McCart. I'm a Deputy District Attorney in the Los Angeles County District Attorney's Office. My specialty is child sexual assault, sexually violent predator law, sex offender recidivism, and child abuse. When the Los Angeles County District Attorney's Office came to be a co-sponsor and an entity that helped author the bill essentially at every step of the way, we wanted to make sure that this was a bill which protected future victims, which was pro-law enforcement, pro-district attorney, and that it absolutely made sense. Part of this was to ensure that there was insurance policy after insurance policy built into the bill. Some of the features that are built in are the tier that you are placed in, the years of that tier, it does not begin to run until you're released from custody or civil commitment. For example, if a rapist was sentenced to 15 years, when they got out 15 years later, they would have another 20 years on the registry, meaning that it would be 35 years before they could even begin to petition. That person would have had to have complied with the law, never committed another violent or serious offense, properly registered, and then would still have to petition to get off of the registry. Part of the other insurance policy that we put in place is that when someone wants to petition to get off the registry, they go into their local law enforcement agency, they have their record run, their registration run. The police actually have a say and actually give input as to the person proceeding with their petition. Then there's another insurance policy. It goes to the district attorney. They have the right to oppose anyone getting off the registry. People don't automatically get off when their tier expires. it must go through the district attorney's office and law enforcement. The other measure which we have already in existence in the state of California is since 1996 we have had a sexually violent predator law. In 2006, it was even made stricter by Jessica's law. Any person in the state of California who goes to prison on a predicate sex offense is evaluated when they are going to be released by the Department of Corrections and the California Department of State Hospitals. If they are still found to be a likely risk, then they are civilly committed in an indeterminate commitment to Coalinga State Hospital, and they are not released from custody. So we already have that insurance policy in place. When that person is released, that person's tier just then begins to run. One of the important aspects of the bill is every single offense which is now registrable remains registrable. All of the serious offenders who have committed violent child molestation, who have committed murder, who have committed kidnap, they all remain in the lifetime tier. Absolutely nothing has changed as to that. We maintain that they are a risk and they remain lifetime. As District Attorney O'Malley stated, we have the static 99R and it is highly predictable. Anyone, period, even on their first offense, if they are found to be one of the people who are high risk on that tool, it is lifetime registration. That is yet another insurance policy that we have put into place. It has become evident to us, those of us who are child sex crimes prosecutors, that the list has become meaningless. There is no way when a child is kidnapped or we have a stranger molestation to go to the registry and use it as an investigative tool, because everyone, including the 80-year-old who committed an indecent exposure 60 years ago, is still on the list. We need to have the purpose of the list restored. It is for law enforcement to be able to go to the list and see who are the risky offenders in their area when a child is kidnapped, to be able to look at it and quickly find suspects and try to prevent that child from having any future harm or possibly death. The Los Angeles County District Attorney's Office wanted to make sure that we had a common sense bill which brought into the bill all of the science that we have learned in the last several decades and hopefully prevent there from being future victims. Thank you.
Thank you.
Hi, good afternoon. Thank you, Chair. My name is Lorena Campos.
My name is Lorena Campos. I am here representing the California Coalition Against Sexual Assault on behalf of our Executive Director, Sandra Enriquez. And, you know, as the professional organization representing 84 rape crisis programs, we know that the current sex offense registry does not improve the safety for survivors, as they have mentioned before, of violence, and often undermines the rehabilitation and reintegration of those who have harmed. Research indicates that most sexual offenses are committed by someone the victim knows, either a family member, friend, intimate partner, or acquaintance, which can have unintended consequences for survivors and create further victimization. So we ask respectfully for your aye vote on this bill. Thank you.
Thank you. Other witnesses in support, just your name and identification.
Dan Filisato on behalf of the Los Angeles District Attorney's Office. We're a co-sponsor of the bill and here to answer any questions.
John Lovell, in the interest of time, I'll just incorporate by reference all of the folks I have indicated in other testimony. With one exception, the Riverside Sheriff's Association was inadvertently included on the coalition list. They do not support the bill. I informed both Committee Counsel and Republican Counsel and the author's office of that oversight, and I apologize for that confusion.
Madam Chair and members, Joe Michael for Equality California. We are a co-sponsor of this bill specifically for the LGBT impacts that Senator Wiener mentioned, in strong support. Thank you.
Natasha Minsker, ACLU of California, in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California, in support.
Marty Veronica on behalf of the California District Attorneys Association, in support.
Janice Bellucci, Alliance for Constitutional Sex Offense Laws, in support.
Kim White, Huntington Beach, California, in support. I'm Ray Lee from Los Angeles, and I support.
Again, Sherry, mother of a sexual abuse survivor, Sacramento County, and I in support.
Brett Oleski, Sacramento County. I support this bill. Please pass it.
Joshua Klump from Sacramento, and I support this bill.
Lynn McGovern, Ventura County. I support this bill.
Emily Juneau, on behalf of Root and Rebound, I support this bill.
Jay Rice from Novato, California. I support this bill.
Stanisha Boatner, on behalf of the California State Association of Counties, in support. Thank you.
Mike Bowles, father of 3, grandfather of 1, in support. Thank you.
Blas Lozano from San Mateo County. Strongly support this bill. Thank you.
Roger Honeycutt, Modesto, strongly support.
Hi, I'm Pam from Santa Clara in support.
Hi, my name is Amal Kumar, and I strongly support this bill. Thank you. From Stanislaus County.
I'm Stacy Kumar. I'm from Stanislaus County, and I strongly propose this bill.
Robert Reed from San Bruno. I support this bill.
Aaron Byington from Sacramento, and I support this bill.
Alex Stewart, Citrus Heights. I strongly support this bill. Thank you.
Hi, my name is Arax Kraling. I'm from Woodland Hills, California, and I support this bill. Thank you.
Hi, my name is Dale. I'm from Sacramento, and I support this bill.
I am David Heron from El Dorado County, and I strongly encourage you to support this bill.
Robert Curtis from Orange County, representing hairdressers across the state. Please support this bill.
Ted DeMond, Huntington Beach, support this bill.
Doug Enlow, I support this bill.
Julio Orellana, Los Angeles. I support this bill.
Carol Urey, Returning Home Foundation, in support.
Joseph Blasey, San Mateo County, supporting this bill.
Hi, I'm Bruce Hamlin from Orange County, California, and I support this bill.
David Adler from San Jose, California, and I strongly support this bill.
Mary Heron from El Dorado County, and I urge you to support this bill. Thank you.
Russell Atkinson of Danville, I support this bill.
Dave Howe, Alameda County, I support this bill.
Douglas Juris from Sacramento, single father of 3. My children and I all support this bill.
Jason Morrow from Elk Grove, I support this bill.
Mark Burba, San Jose advocate, on behalf of all the thousands of sober, law-abiding, tax-paying, productive members of society who are on the registry, I support this bill.
Good afternoon, Madam Chair. Rosanna Carvacho here on behalf of the Alameda County Board of Supervisors in strong support.
Khalif Asagай, California Public Defenders Association, also in support.
Chair and members, Jonathan Feldman with the California Police Chiefs Association in support. Thank you.
Dan Heron from El Dorado County, and I support this bill. Thank you.
Frank Lindsay, Grover Beach, California, ACSOL board member, and I support this bill.
Any other witnesses in support? Then maybe we have witnesses in opposition, and those of you in support will need to leave the table. Thanks. Yes, here it is. Please proceed.
My name is Nicole Pittman. I'm the director on the Center on Youth Registration Reform at Impact Justice in Oakland, California. I'm as well as the leading national expert on impact of sex offender registries on juveniles. We are neutral on Senate Bill 421.
Could you hold your testimony so if there's anybody at the table who's in opposition so that I can hear the...
Absolutely.
Any in opposition, or are you all tweeners? Opposition, go ahead.
My name is Micah Moulton, and I'm the founder of Christopher's Clubhouse, and I'm representing all surviving parents of children that were sexually assaulted. In 1985, I lived in California when my son Christopher was born, but a few years later, we moved to my hometown in Illinois, and Chris, at the age of 10, was abducted, heinously assaulted, and brutally murdered by a repeat offender. Megan's Law was sitting on the desk of our governor at the time and had not yet been signed. I moved back to California 10 years ago, and I've been working tirelessly to ensure our communities are safe and to provide prevention education to keep children safe and to provide all-over public safety. My opposition comes from the lack of clarity in several sections and great monetary costs to our state. While not clearly specified in the bill, it is presumed that the state's sex offender registry, which is the California Department of Justice, will be responsible for retroactive tier assessments for registrants totaling over 100,000, thus creating significant monetary costs on the department. Immediately upon implementation of the bill, approximately half of all Tier 1 and Tier 2 registrants could be eligible to petition for termination. Penal Code 261.5 is the statutory rape code, and it is not a registrable offense in California, which means that those Romeo situations that were testified to, which is the 19 and the 17-year-old, those are not considered a sex offender situation and are therefore not impacted by changing this law. A tier system is an excellent idea, but not as currently written in SB-421. How can we justifiably say that exposure with intent to commit lewd and lascivious acts against a child, or that possession of child porn is something that doesn't need to be listed on Megan's Law site? How can we say that? Statistics repeatedly show that an offender molests usually about 30 times before ever being caught the first time, and that initial crimes are normally not enough to continue the perverse pleasure they receive. They usually have to accelerate the crimes to more sexually violent offenses. So the bill as currently written would say these offenses and many others are not bad enough to be greater than a Tier 1 and therefore not worthy of listing on the public site. Stating that there are too many registrants on the system for the public to decipher seems to be saying the public is not smart enough to know how to read or use the internet registry. The parents I know and the majority of the community use the registry to be aware of those around and to be informed. The registry clearly lists what the offender's crimes are. Parents want to know who live in their neighborhood and want to be able to let their kids know where to stay away from. And arguments state that recidivism is not a thing. I can tell you that if I knew there was an offender in my neighborhood, you can be sure that I would have told my kids and shown them a picture so they knew exactly who to stay away from. And if I knew, I'd probably be playing with my grandchildren right now instead of sitting here, because my son would be 32 years old and probably married with kids instead of buried in a cemetery. A registered offender was convicted in Riverside County, my county, that's where I live, just last week, of attempted lewd acts on a child, annoyance of a child by a registered sex offender, and 2 counts of being in possession of child porn. He tried repeatedly to lure this child in his car, flashed money to get her attention, and followed her as she tried to get away. The loss of a child through death or innocence is a loss like no other. And when I stepped out of that limousine to walk across the grass to my son's gravesite, I saw that beautiful royal blue coffin carried by the kids in their neighborhood he played with. I never imagined I could move beyond that horrible pain and gut-wrenching knot. But here I am to let you know that I believe a tiered system is important, but that it needs to be written to benefit the families and communities, not the offenders. We need to take a step back and work together, both sides of this issue, to make it mutually beneficial to all members of the community. Because sexually assaulting a child is not something that is forgivable or that happens by accident. And losing a child is something you can never imagine before or after it happens.
Thank you for your testimony. Is this in opposition?
Yes, sure is.
Please proceed.
Yes, my name is Mark Klass. I'm the president of the Klass Kids Foundation. We started Klass Kids in 1994 in the aftermath of the kidnap and murder of my daughter, Polly. In 1996, roughly at the same time that Megan's Law was signed into law, we created our website, classkids.org, and since 1996 we have put a comparative analysis of every state's Megan's Law, or we've published that on an annual basis and updated it. So I don't come lately to this particular issue. I can't really add a lot to what my dear friend Micah has testified to, and we were actually brought together years ago through our common tragedies. But what I would like to do is I would like to remind the committee and all those who sat here in support of this piece of legislation that the real victims here seem to have no voice. That this whole idea of victimizing sex offenders, individuals who made decisions to harm other people, is, I find personally offensive in every way. My daughter was the victim. Micah's son was the victim. All of those thousands of rape victims that are out there that quite possibly agreed to a plea deal believing that their offender would somehow be held accountable for their crimes for their lifetime, as they were told, are the real victims in here. So this idea of turning offenders and somehow flipping this over and turning the offenders into the offended, I find extremely offensive. Thank you for your time.
Thank you. Any other witnesses in opposition to the bill? This is not the tweener right now. It's the opposition to the bill. All right, seeing none, you may speak.
Thank you.
Or the person that just stood up, are you standing to? Okay. All right. Go ahead.
Okay, thank you. Thank you. My name is Nicole Pittman. I am the director of the Center on Youth Registration Reform at Impact Justice in Oakland, California, as well as the leading national expert on the impact of sex offender registry laws on juveniles. We are neutral on Senate Bill 421, while the bill, as it relates to adults, is a step in the right direction. But we're concerned about the implications for juveniles who are currently treated the exact same as adults in the bill. Since 1986, California has placed thousands of children handled in juvenile court on the state sex offender registry for life, many of whom are 14 and they're with a 12-year-old, and because someone under the age of 13 cannot consent to sexual acts, they are on the registry. Holding children appropriately accountable for harmful behavior and providing them with evidence-based treatment can reduce their likelihood for future offending. Subjecting them to registration cannot. Juveniles handled in juvenile court should be treated differently because they are different. They have vanishingly low recidivism rates, less than 3%. Rehabilitation, not lifelong stigmatization, is the cornerstone of the juvenile justice system. Brain science shows that children are works in progress and that laws must be calibrated to the reality that children are fundamentally different than adults, not miniature versions of adults. The correct response is fully remove juveniles from registries. There are 12 states that do not register juveniles. Their recidivism rates are actually lower than the other states. They're 1%. Please do understand that we are neutral and we have been engaging with the author and the sponsors of the bill. Really, who's been amazing is Dan Filizano. We also work with CalCASA and National Alliance to End Sexual Violence in almost every single state. Equality California as well. To align, but we've looked to work with the sponsors to align this bill with the state's movement towards improving outcomes for system-involved youth. I look forward to continuing to work with them on this issue. Thank you for giving me time.
Thank you. Any other tweeners? All right, seeing none, we'll have committee discussion now. I know that our vice chair is co-author on this bill, so apologies that he's not able to be with us right now, but I'm sure he would speak to it. And I will allow Senator Stone. Go ahead.
Thank you, Madam Chairwoman. I first want to extend my condolences to Ms. Moulton and to Mr. Kloss, and I appreciate their attendance here today. I've been dealing with sexual registrants. This is my 25th year, 10 years on the Board of Supervisors, 12 on the City Council, and Riverside County has between 3,000 and 4,000 registered sex offenders, and we've adopted some of the toughest ordinances in the state of California to make sure that we can keep an eye on them. You know, we keep a lot of databases in the state of California. We keep fingerprint databases, photo databases, gang registry databases, arson databases, and we should keep a sexual registrant database. I'm a proponent for keeping it for life, understanding that there are mechanisms in place for people to get themselves off of those registries if necessary. But by having a lifetime registry, if we can save just one life in the state of California, we can prevent the Kloss family, like the Moulton family, from experiencing the pain and tragedy and the heinous acts that some of these sexual registrants impose upon their victims, then we should do that. I think we should err on the side of the victim, especially those victims who have been murdered and been left with no voice to testify here at the table here today. So I regret that I have trouble with the bill, especially the retroactive provisions of this bill that will allow a large percentage of Tier 1 and Tier 2 registrants to be taken off the registry as soon as 2018. I know citizens in my district, in my communities, want to be able to go on websites, vegans' websites. It wants to ensure that they know who is potentially a dangerous individual with respect to sexual crimes that lurks in their neighborhood so that they can be very protective of their children. I can't think of one parent in my county that if you ask them, do you think we should take registered sex offenders off the list that you can look at online? Do we think we should take any registered sex offenders, take that designation away from them? And I would be hard-pressed to find anybody that would support such an idea. So in honor of the victims, those who have been murdered by sexual predators, understanding that many of these sexual predators have committed many, many crimes before they get caught, and also having family members of my own family that have been victimized sexually in very unfortunate ways without mentioning their names. I can't in good conscience support this bill.
Senator Mitchell.
Thank you very much, Madam Chair. First of all, I note in the analysis that there was no opposition received. I checked my own binder, checked with my office, and I didn't receive any letters of opposition or tweeners. The challenge with that as a sitting policymaker is we don't have the opportunity to review the opposition in detail, ask questions. I don't know whether the opposition, if they didn't inform the committee, therefore inform the author, engaged in dialogue with the author around the nuance of their opposition to the language being proposed. We all know as policymakers that policymaking is not black and white. It is not as simple as, do you like bad people? Do you want your children exposed to bad people? It is much more nuanced. And given that, we have a responsibility to dig deep and consider both the emotion and the science and the practical application of law in making our decision. And when I am not empowered with the information from proponents and opponents, that complicates matters. Let me say to the author, I tip my hat and congratulate you. If you take amendments today, I'd like to be added as a co-author. Because of our conversation earlier on the LEVA bill, I am clear, based on the science, based on the expertise before us today, that now is the time to have a different kind of informed conversation about sexual predators and how they are dealt with in society and reintegrated into society. So congratulations for bringing all the powers that be together. This is the beginning of what will be a long, complex conversation, hopefully looking at the LEVA bill, your bill, and figuring out how we indeed come up with the best policy based on what we know today. You, Madam District Attorney, spend more time in this committee than I can imagine, so I want to thank you for always bringing us your years of expertise to help kind of inform our discussion. I'll be supporting your bill today. It is not an easy decision. Any discussion around reform or looking at our current criminal justice system to figure out if it continues to make sense today. And it's not about picking, I support predators over victims. That's not the case. We have got to figure out a way to develop and refine a system based on new information that we have today that protects all Californians. And I believe your bill is setting us on the track to come up with this tiered system. And for those reasons, I'll be supporting you today. Thank you, Madam Chair.
Thank you, Senator Mitchell. Now I want to make some comments. And first, I do want to express my not only condolences, but appreciation to the Moulton family for being willing to come again and again and, in fact, relive the pain of your experience of loss of a child. And it is something that one can't even really imagine. I just know from, and I know every single parent, the love of our children is so strong that to imagine that or experience that our child would die before us is beyond fathomable. So I want to express that with my deepest, deepest feelings. This is a matter, as has been raised already by not only the witnesses, by the author, but by my colleague, is that we have to be able to separate emotion from fact. And we are one of only 4 states that has this lifetime registry. And the unfortunate circumstance is that it has not served the purpose for which it is intended. And we want to ensure that those people who are violent, who are sexual predators, that our law enforcement has the best ability to, if there's any incident of alert, that they know exactly who to try to get to right away to determine whether that person is involved in the circumstance that is pressing at that moment. And as so many things, California, we put over the years many things, whether by the legislature or by voters, into place without fully understanding the implications of it. Now I will speak in an emotional way. I am a person who was abused for many, many years of my childhood. And we know by data that the primary abusers are people that you trust. And by virtue of that, those abusers are the ones who are the least likely to be charged and convicted. Because especially in the case of childhood abuse, if it is someone, a family member, your family, that only occurs because the condition, not only, I don't want to be so strong, but rather it is likely to occur because the condition of the family is such that the family will not recognize it. And the child is not treated with the ability to come forward with that abuse because then they are basically accusing a trusted family member. So they know that they will not be believed. So they do not. And thus we have many, many perpetrators who are never brought to charge because it is someone very close. Now, so in those few circumstances, or maybe I'm being a little too extreme, not few, in those instances where the family member is charged, they are not on the public website. While they are sex registrants, they are not on the public website. So I bring this up very strongly because I greatly appreciate that people are trying to make sure that we are ensuring public safety. But when we have the illusion that abusers or sexual assault are people that are somehow the stranger, when in fact it is someone, usually, that is trusted and known to the person abused, and that often is protected due to the authority that they have over the child. We are not achieving public safety through the way we have structured this. We are not. So I would gladly have the people in my family been on the registry and even convicted, but this did not happen. And if they were, I would still have the same opinion I do on this bill, that this is a reform that we greatly need. Now, on the issue of that we did not have the information from the opponents, some people might indicate, well, Senator Wiener's bill was only in print very recently. But in fact, this bill has been in print under a different author's name since the beginning of session. And while it was not scheduled yet for hearing, it was in print, and certainly any entities who are following this debate had ample time to be able to submit to us the opposition so that we could analyze it properly and that we could have entertained, if appropriate, modifications or amendments to the bill. I personally feel that there's probably some of the crimes that are now offenses that are listed that become registry offenses that probably we should reconsider. But I know that this is such a charged subject that the very first move to try to fix our registry and make it tiered should not be complicated with also adding some limit on the type of crimes. But I would hope that the same criminal justice advocates, public safety advocates that are here today, and we've heard from many, who have been monitoring our registry and its use, can at some point in the future, if we are able to do this initial reform, can also help us look at whether we have the offenses properly categorized. And then I also want to just say lastly, that I have not spoken publicly about my experience, except once on the assembly floor. And I do so right now because I think it is very, very important for those of us who have been abused to bring it out of the covers and to talk about it publicly so that family members feel comfortable and we remove this sort of like the military, don't ask, don't tell. We remove this and we create safe circumstances where any person, any child, the instant they feel violated, have trusted adults that they can go to and they can be acted upon. Now, that is not the full subject of your bill, so apologies that I diverted, but I think you're very courageous to bring forward this reform. This reform will be difficult for people, but our registry is not working in the way that we have intended. I appreciate all of the law enforcement and public safety personnel who have spoken so clearly about this and given very long and good thought to it. And I know that this will not necessarily be popular to many people, but is often times where we are asked to do things that aren't necessarily popular, but that are very important so that we ensure that our laws are accomplishing that which we have intended. So if there's other comment, I'm happy to entertain it. So moved. Thank you. Senator Wiener, you may close.
Thank you, Madam Chair, and thank you for sharing that, what I know is a very difficult situation to talk about, so thank you. And I also just want to express to the opposition witnesses, I will never understand what it means to lose a child in any circumstance, and particularly in that way. And I'll tell you, it is incredibly hard to sit up here with people who have experienced such profound loss and tragedy in their lives, and I just can't even express just the horror of thinking that anyone goes through that. But we know that in this world people do, and we have to do everything in our power to stop that and to keep these kids safe, and that's why we're doing this. I would never in 1,000 years author a bill if I thought that it would place anyone at risk, and particularly children. But the reality is that the sex offender registry in California is a failure. It is a failure. And we've heard it from law enforcement. You don't have to believe me. We've heard it from law enforcement that if something bad happens and you're trying to pull up a list of possible suspects and it is a massive list of people, that is not going to be helpful. We need to focus this registry on people who are a risk of reoffending, and that's what this legislation does. It will. I think this is a positive step forward, and that's why CalCASA is supporting it. That's why law enforcement is supporting it. I do want to just note one thing in terms of the statement that was made before about the Romeo and Juliet situation. I do want to reiterate that if you are gay, then you are a registered sex offender. If you are 18-year-old having sex with a 17-and-a-half-year-old and you are gay, you are a registered sex offender for the rest of your life. So there are some real disparities in this registry system in addition to the fundamental problems with it. And so, colleagues, I ask for your support.
So we have a motion. It is due pass as a, not amended, just to, sorry, I'm there. Right, and Senator Wiener, I would like to be added as a author to the bill.
Thank you, Madam Chair. And Senator Anderson did express to me before that he would like to be co-author as well. And so we will make those amendments. And Senator Mitchell as well. Thank you, Senator Mitchell. We'll make those amendments.
All right, so it's due pass to, with the amendments to appropriations. We can have the roll call.
Yeah. We could do them in appropriations. They have amendments to do it.
Okay, that's fine. That's fine. So we'll just, okay. All right, roll call, please.
Motion is due pass to appropriations. Skinner?
Aye.
Skinner, aye. Anderson? Bradford? Aye. Bradford, aye. Jackson? Aye. Jackson, aye. Mitchell? Aye. Mitchell, aye. Stone? No. Stone, no. Wiener?
Aye.
Wiener, aye.
We will hold the roll open on the bill.